Thanks for staying with us. Now, the federal government of Nigeria has announced plans to implement the court judgment allowing political appointees to run for office without resigning. Now, Attorney General and the Minister of Justice, Abubakar Malami, made the government's position known in a statement on Friday night that the federal government's announcement came hours after the Federal High Court sitting in Umuahia nullified Section 84, subsection 12 of the newly amended Electoral Act, saying it violated the provisions of the Constitution. Now, the Punch had reported that Malami, the Minister of Transportation, Amechi, the Minister of Labor and Employment, Chris Ngige, and other political appointees believed to be interested in elective offices will not be able to participate in the All Progressive Congress primary expected to begin in May unless they resign. So we are analyzing this court judgment, allowing Amechi, Malami, and others contest primaries, and what does it mean for us, for our elections, for our electoral acts in Nigeria. How would it affect us, as citizens, and how would this sway voters' decision? Now, please let us hear what you have to say. Remember, you can join the conversation. Send us an SMS or WhatsApp to 081-803-84663. You can also tweet at us at PlusTvAfrica1 with the hashtag PlusTvAfrica. So, Manny, it's quite interesting. I want to bring in our guest in like a minute, but I wanted to hear your thoughts on this. Because just last week, Monday, we had Gbadebo Road's Vival. We were celebrating and we were excited about this decision that the Electoral Act, the provision, I think we celebrated too soon, where he was talking about that this gives a level playing field for everyone. Because again, you cannot underestimate the power of a sitting political appointee and the kind of whatever he can wield, the kind of arsenals he can wield when it comes to going into the primaries with somebody that is just a regular citizen, right? So that he was very excited about this, that because it was going to at least give everyone plain level field to play. The one court in Umuahia decided to just come and scatter the whole thing for us. But what are your thoughts on this?
Okay. What are my thoughts on this? Well, I just think that this whole thing has been branded as a very offensive provision right now, and I'm going to be very political. I just think, Falana has a point here. We have to look at what the political appointee is and what a public servant is. So when you can define the two properly, then you know what it is. Yes, it's about this. It's about being who can run. If you want the political appointee to stay away, then you have to you nullify this. So the court, the judge in Umuahia that has nullified this provision, saying that it does not apply to only public servants but to political appointees. Is she right or is she wrong? So we have provisions. There are cases. There's a case in I think it's Dana versus something that has already nullified what she has said. Yes. So I am of the opinion that the judges, these political appointees are not supposed to run. So the celebration that you celebrated last week, even though it was too soon, but I think it's in order. Yes, because if you occupy a position, a seat, I think you're not supposed to contest in the primaries.
Except you resign.
But right now, they are coming under the umbrella of the public servants, because the provision states that as a public servant you can contest in the primaries and only send in your resignation 30 days before. Yes.
Yeah. Lawyers, people always find a way. Let me bring in our guest, Ibrahim Lemu. Lemu is a legal practitioner, legal analyst, political commentator. He is the principal partner at Aliyu, Lemu and Co., a legal practitioner of over 15 years, standing and engaged in active practice in diverse areas of the law, with office in nation's capital and practice of law across diverse areas of the law nationwide. He's an alumnus of the Ahmadu Bello University, Zaria, and the Nigerian Law School, Lagos. And he's joined us live from Abuja. Thank you so much, Aliyu.
Thank you very much for having me on the show.
So,
secondly,
yeah, go ahead.
Secondly, I would like to thank you also for bringing this subject to the forefront of public discussion.
Thank you.
For a very long time, Nigerians have not had something to unite them like this, like the present outrage over the judgment that was delivered by the Federal High Court in Lemu here.
Go ahead.
If we'll be permitted to speak plainly to what it is, it is what it is. A few group of political appointees are trying to undo the good work of the National Assembly. The Electoral Act is one of the most important single legislation that has been passed by the 9th National Assembly. Nigerians have lauded the National Assembly for passing this law and creating a level playing field for all Nigerians of different political backgrounds.
Which is good.
But like we said at the beginning of this program, a few individuals in the federal government, political appointees, who are afraid of contesting an open contest where a level playing field is guaranteed, choose to find a way of subverting the will of the National Assembly and the will of the Nigerian people. We must all stand in unison against that. So thank you for affording us this opportunity to bring this subject to the front border of public discourse.
All right, thank you so much. So let me even understand this issue, because on Monday we were so excited. Just last week Monday, we were excited. You know, we had a guest that was saying this is history. This is good for our politics. This is good for the elections. It means that, you know, real candidates will truly emerge. You know, when they're done conducting primaries and all of that, then all of a sudden this just happened. First of all, why are lawyers, judges or whatever, why are you people confused? You know, was it even right in the first place that this case that is supposedly in my head supposed to be taking place in Abuja, one court in Umuahia just decided, you know what, let me just go and scatter everything for you people? Like, you know, I'm in the midst of lawyers, I have to be careful before they sue me and take me to jail.
Actually, there's nothing wrong with Nigerian lawyers and there's nothing wrong with Nigerian judges. Nigerian lawyers are one of the best in the globe, and Nigerian judges also are pace setters globally. Nigeria appoints judges to other African countries and international courts of justice. So we have very good judges on the Nigerian bench, just as well as we have very good lawyers in the Nigerian bar. First and foremost, let me premise my discussion with saying this judgment of courts, all judgments of courts must enjoy respect from emanating from courts of law. The courts of law are creations of the Constitution, and because they have been created by the Constitution, we are all bound to respect whatever decision that comes from the competent court of law, in this case, the Federal High Court. Let me correct a notion. It doesn't necessarily mean that this matter must be heard and determined in Abuja. The court that had this matter is the Federal High Court. In lawyers' terms, the Federal High Court is one court. It's a single court in Nigeria with different judicial divisions. Any subject matter that concerns the federal government or any of its agencies or the interpretation of the Nigerian Constitution is a matter that can be brought before any Federal High Court in Nigeria.
Wow.
So it is not wrong to commence this matter at the Federal High Court more here. What is wrong is the secrecy with which this matter was commenced, with the alacrity and the speed with which this judgment was delivered, that has left so many questions begging for answers. As it is at the moment, it is a valid judgment of court, whether we like it or we don't like it, whether we agree with it or we don't agree with it. The option open to parties who are not happy with this judgment to go on appeal. Unfortunately, the way and manner this matter was commenced smacks of connivance between the person who instituted this matter and the Office of the Attorney General of the Federation, who is supposed to be representative of the Nigerian people, defend the will of the Nigerian people, and uphold the laws as passed by the National Assembly. For the first time in a very long time, you can see where two lawyers who are supposedly fighting have come out in unison to applaud the judgment, which is a defeat to the Office of the Attorney General. The lawyer representing the office came out and was happy. And the Chief Law Officer of the Federation, who had this judgment on the news and social media, even before he read it, even before he was served a copy of this judgment, was quick to announce to the world that they are going to implement that particular judgment. These whole scenarios are the things that make this judgment suspect. But we must respect the judgment for what it is. It's a judgment of the court of law. Then, what I want to bring this to the public attention. The law passed by the National Assembly was assented to by the President on the 25th of February, 2022. Between that time and the time the court delivered judgment is a period of exactly 21 days. By the procedure of instituting matters at the Federal High Court, if a matter like this one is filed, the defendant who is supposed to answer to this suit must be given a period of not less than 30 days to file its answer to the suit against him. And after filing those answers within 30 days, the person who filed this matter is also given a period of 7 days to respond to any issue that will be raised from the defense of the Attorney General's office. So what it simply tells you is that less than the time within which the Attorney General should have responded, less than the time within which the plaintiff should have further responded to the claims of the Attorney General, the court hurriedly had this judgment, took arguments, and delivered judgment in record time. I don't think there's any judgment in the history of Nigeria that has been ever delivered as fast as in this.
So, Aliyu, are you not now contradicting yourself when you said that we should uphold that so is it not already fraudulent? So shouldn't you, declare that judgment fraudulent?
I do not have the power, and neither do you have the power to declare that judgment fraudulent. By the law establishing the courts in Nigeria, it is only a higher court, and in this court, the Court of Appeal, which is a superior court to the Federal High Court, that can declare this judgment null and void, and as well as setting it aside. But it does not behove on me and you to declare it fraudulent. We have to respect it.
So how do we get on from here? So who is supposed to file to the Supreme Court or Court of Appeal? Yeah.
Ideally, this matter should not have been heard without the National Assembly. The National Assembly ought to have been a party to the judicial proceedings. It is the law that has been passed by the National Assembly that is sought to be set aside. It is the fundamental right of the National Assembly of the Federal Republic of Nigeria to be heard in respect of the law which it passed before any court can set it aside. The failure to join the National Assembly to this suit is a good news, because I tell you, as soon as this matter gets to the Court of Appeal will find no hesitation in setting it aside, because the parties that ought to be joined as proper and necessary parties to this suit were not joined before this court thoroughly gave its judgment. So I will, by this medium, call on the National Assembly of the Federal Republic of Nigeria. Even though they are not original parties at the trial court, they have the right to seek the leave of court, appeal this judgment as a party interested as a party interested and affected by the outcome of the judgment delivered by the Federal High Court.
Okay, this is getting interesting. Money. All legal people. You guys just confuse me all the time.
Okay, well, it is what it is. He has already said it. The necessary parties have to come into play. We can only complain, but nothing will be done unless they move. So, my learned friend, I would like to ask you a question. What is the implication of allowing these people to contest while in office?
Well, until this judgment that has been passed by the Federal High Court is appealed and set aside, they will be within their rights, premised on this judgment, to contest. Or otherwise, the spirit and the intention of the law as passed by the National Assembly is that political appointees must resign their appointment before participating in any party primaries.
Okay, me, I'm just getting a bit worried, right? How does this impact the strength of the National Assembly, that they all came together, created the document, the Electoral Act, it had the accent of the president, and all of a sudden somebody can just go from, and I still want to stand on that I think it is wrong for them to have even gone to, you know, at least they should have taken it to a federal high court, maybe in Abuja or something, so that all parties will be involved that started the process can also walk through the whatever it is that they're doing. So how does this, what is the implication of this move, right, by this federal high court in Umuahia on the strength and the credibility of the or the strength rather, because let's focus on their strength as a National Assembly? How does this impact them?
Okay, let me explain it in simple terms. There's one federal high court in Nigeria. It doesn't matter where the federal high court is. But there is something fishy in this particular case because this matter was instituted with secrecy. Let me take you back the timeline a bit, timeline of the Electoral Act as amended a bit. When this law was passed was assented to by the President on the 25th of December, he made mention of the fact that he will request the National Assembly to make an amendment to Section 84 sub 12. That request was presented to the National Assembly. And on the 9th of March 2022, the National Assembly overwhelmingly rejected the request of Mr. President to amend Section 84 sub 12. On that very day, the Attorney General of the Federation, through his office, came out to the media on the 9th of March to say that even though the National Assembly has rejected the request of Mr. President, they will find other ways of dealing with the issue. So between that date, 9th of March, when it was mentioned that they will seek other ways, it is supposedly reasonable to infer that on that particular date, if that case had been filed on the 9th of March, the Attorney General of the Federation ought to have informed the public that there's actually a pending case before the High Court, Umuahia, where this same issue has been submitted for the determination of the court. But the office kept quiet, meaning there was something fishy. On that day, they are probably aware. Or the other alternative will be on that day, there was no matter in court at that time on the 9th of March. So it probably meant from the period of 9th of March to the 18th of March was the period when this matter was filed, heard, and judgment delivered on the 18th of March, a period of 9 days later. Whichever way you look at it, this does not paint our system of the administration of justice in bad light, in good lights. It casts the office of the Attorney General, who is supposed to be defender of our institutions, in bad light. It brings a bad spotlight on the judiciary, which the majority of the public is now reasonably inferring that there is something fishy, there is something irregular about the way and manner this case was filed and judgment delivered in this matter. The judiciary must stand to defend its integrity and prevent itself from being used by scrupulous politicians from bringing the judiciary to disrepute. Judges must stand and be representatives of the will of the Nigerian people. Judges must stand upright to be the representative of the Nigerian judiciary. They must be the first, middle, and last hope of not only the common man, but all Nigerians of diverse political backgrounds.
Okay, let's go on a very short break, right? When we come back from the break, I'd really like to, because this thing you've said now, this is what gets us worried as Nigerians. You know, say now I be the lawyer. This is what gets us worried. This is why we do not go to court, because we feel like once a big man, you know, you are having a case against a big man, justice will never prevail. The big man will always win the case, because there's a ripple effect when we think that some people can actually buy their way, you know, all the time and have their way. You know, it just kills that entire system of justice. That
miscarriage
you know,
of justice.
Yeah, miscarriage of justice. You know, now I know the terminology. We want to go on a break. When we come back from the break, we'll just continue this conversation. Stay with us. We'll be right back. All right, thanks for staying with us. If you just tuned in, we are analyzing the court's judgment allowing certain political appointees to contest in the primaries And we have with us Aliyu, Ibrahim, Lemu. Please let us hear what you have to say. Remember, you can join the conversation. Send us an SMS or WhatsApp to 081-803-4663. You can also tweet at us at PlusTvAfrica1 with the hashtag WaysShow. So before we went on a break, Aliyu, so I had asked this question because this is what gets a lot of regular citizens in this country wary of going to the courts, because they just feel like everybody, that is powerful, like you have means and all of that, you can always, sway judgments to your favor. So how is this going to impact the judiciary system of Nigeria beyond even politics? Because now you're turning it and twisting the laws so that it can favor you politically, but it goes beyond politics when it comes to the justice system in this country. So how is this going to impact?
Well, for one, it's going to impact on the public perception of the Nigerian judiciary. For a very long time, the Nigerian judiciary has been on trial. There are several complaints of justice being denied. The poor man will file their cases and the cases will linger in court. There are cases that last for between 30, 40, and 50 years within the Nigerian judicial system. Poor people will file their cases and they will linger in the court system. But powerful men, strong politicians, rich men always have justice served them the way they want. This is the average perception of this is the perception of the average Nigerian with respect to the judiciary in Nigeria. Well, of late, the judiciary is trying to redeem itself by making amendments to rules and splitting up the system of administration of justice. The heads of court in the various courts in Nigeria, starting from the High Court, Court of Appeal, all the way to the Supreme Court, they've passed legislation and made rules that will lead to a speedy and a faster system of administration of justice. But to sound a note of caution, justice expedited is not always justice. Sometimes the system must be allowed to take its proper course. The judges are also human beings. You have cases and scenarios whereby a single judge will be tasked with hearing 20, 30, or 40 cases in a day. But these people are human. There's only so much they can do within their limited capacity as human beings. At this point also, the federal government needs to come into place by enhancing and making a better and more conducive environment to judges, by enhancing their welfare and salaries, by recruiting more judges, by recruiting more lawyers in the ministries of justice and departments of public prosecution, to move the system of administration of justice faster and better than the way it is 10 or 20 years back. There have been little changes here and there, not the ones that the average Nigerian can see, but we as lawyers in the system of the administration of justice, we are parties to the effort being made by the various heads of courts to expedite and enhance the system of justice delivery in Nigeria. But despite all of this, more can be done. I believe members of the bench as well as the bar are listening to this program, and we are calling out by this medium, appealing to those with the powers to make these things happen for the benefit of Nigerians. We are calling upon you to ensure a better and expedited system of administration of justice in Nigeria. That is the only way the hope and confidence of the common man will be reposed in the system of the administration of justice in Nigeria. But judgments like just those of Justice Ayadike that was delivered on Friday does very little to inspire hope and confidence in the average Nigerian. A lot has to be done to change that public perception of Nigerians about the judicial system in Nigeria.
It's really scary for me, because if we are appealing to them, what if they don't come out, right? Shouldn't there be some form of checks that whether you choose to do what is right or you choose to do what is wrong, there's a system that will check you. Do you get my point? We can't appeal to consciences anymore in this country, because it seems like
you are part of this system. By this program, we are directly speaking to their conscience, and that if they don't listen, posterity will judge them. There are good judges, there are bad judges. Good judges write their names in the sands of time. 100 years, 1,000 years from now, the good judgment that they have delivered will live long in memory. Bad judges bring disrepute to their family names, to the system, and to themselves. Bad judges go down the path of ignominy. Good judges are ever quoted always. So this is a call out to the members of all stakeholders in the system of administration of justice in Nigeria, that for history's sake, for posterity's sake, let us all do the right thing. And we will not stop. We will not relent. If this call is all we can do for now, we'll continue to make this call. When the time comes to take other ways of achieving this change through legislation, through protests, through other means available under a democratic system, we will continue to do that. And you members of the port estates, the journalists, print and media journalists, you must continue to bring these issues to the front burner so that the sensibilities and consciousness of Nigerians will forever be awake that we must demand for change and we must get change.
It's interesting. Money.
Well, we have the rules of professional conduct. What they are supposed to do is uphold the law and, just ensure that the general public get justice. There's no miscarriage of justice. So I think these things are being done. It might just be a very slow process, but it's something that is being done. Like he said, the change may be minimal, but it is there. Yeah.
Right? So I was going to ask you, what would be the ideal thing? Do you support that section remains in the Electoral Act, or it should be expunged from the Electoral Act? And why do you support it? What's your reason?
Nigerians have clamored for this. Nigerians have yearned for this. And it's in direct response to the yearnings of Nigerians for the existence of a level playing field that the National Assembly enacted this legislation. It is one of the best legislation passed in recent times. And that particular section is a welcome section by all strata of the political atmosphere in Nigeria. Both the ruling party and the opposition party and other fringe parties in Nigeria have all embraced this provision of the Electoral Act, which says that political appointees, irrespective of their parties, irrespective of their states, must resign their offices before participating in the primary election or conventions of their political parties. So it is what Nigerians have asked for. It is what Nigerians have been given by the National Assembly. So for a few set of individuals, for their own selfish interests, to initiate and voice something like this on the Nigerian public is something we must.
So, but why did the National Assembly try to go back to remove that part? Because there was a time they also wanted to go back, or was it the president that wanted to take off that particular session before this move was made?
It was the president that requested that they make amendment to that.
Why?
But because he was advised by his political appointees that it is going to have a negative effect on them. But they are not thinking of the majority of Nigerians who have been demanding for a level playing field for all contestants of political office in Nigeria. So it's the interest of 180 billion Nigerians against the interest of 5 or 6 political appointees who do not want a level playground for themselves and other Nigerians in the political contest.
This is actually very confusing.
Yeah, what they said is that it was unconstitutional, so it went against other provisions. Yeah.
If I could enlighten you a bit, those who are speaking in favor of expunging this provision are basing their argument on a wrong misunderstanding of the law. There are sections of the Constitution that lays down the conditions for anybody aspiring to particular offices within the Constitution must abide by. It provides that all public officers or all persons employed in the public service of federation must resign their appointment at least 30 days before the election. But it speaks about public officers in the employment of the public service of the federation. That has been defined in the Constitution itself. Section 318 defines public officers as staff of the National Assembly, of the Supreme Court, of the various government agencies. but it does not include political appointees appointed by the president or governors or other office holders. And the court of law, the Supreme Court and the Court of Appeal have stated categorically in their judgments that political appointees are not public servants as defined by the Constitution. So there's no ambiguity. The law in Section 84 sub 2 deals with party primaries and party conventions. It has got nothing to do with general elections in Nigeria. The provision says every political appointee must resign his office before participating in his party's convention because of electing delegates or aspirants for any particular office. It has got nothing to do with the national election. And as such, there is no inconsistency with the provisions of the Constitution. This is where we fault the judgment of the Federal High Court here. It is anchored on a wrong understanding of the provisions.
But wait now, is it not you that did the law and you are the ones interpreting the law? But I want to ask a question. You define what a political appointee is, because since a Federal High Court, a judge can actually rule in favor of basing it that because they are considered public servants, I mean, what do you call them, right? So who is a political appointee and who exactly is the public servant? Maybe you should do that clear distinction.
Okay, you see, in this judgment we are talking about, the court did not go ahead to define who a public servant is or who a political appointee is. The court just gave a blanket pronouncement that because Section 42 says they must resign before the primaries, they say it is inconsistent with provision of Section 66, 107, 137, and 172, which says that public officers must resign 1 month before the national elections. That is anchored in a wrong understanding of the law. But the judge is human. Judges err, and that is why we have a court of appeal. If we are not in agreement with this judgment as delivered by the High Court, the next option is to go on appeal before the Court of Appeal. And with the proper arguments, with the proper parties before the court, the Court of Appeal can be able to take a holistic approach to the issues and determine it in the right light. And in this instance, we believe the Court of Appeal will find no hesitation in setting aside these judgments of the Federal High Court here.
Lawyer, my lawyer.
It's a very serious one.
You know? So I don't even know what to say anymore. But if you had something to say in all of this, let me leave you to be talking, because as I am like this, I'm speechless. I want to start singing the song Speechless for you people. You know, so if you had something to say generally based on what you've seen, the antecedent, why do you think there's a push for why do you think there was this what's it called, how did you put it, the very, very slimy way to go and get this ruling? Why do you think they are desperate, the political appointees? Why that desperation to take out that part of the law? Is it that they fear that they cannot stand, you know, what's it called, the primaries or something? Why do you think that is?
You already answered the question. It's because they already have three. They cannot win the election where there's level playing grounds for everybody to come and contest and solicit for votes. These people have not done something, they have not done anything meaningful for this country. They have not done anything meaningful for their constituents.
I beg to differ.
Well, we'll get to that part later. But you see, for anybody who has done something he is proud of, they will not be afraid of going back to their constituents, where they are going to solicit for the votes of the people who send them on national assignment. But they are afraid. They cannot win elections in open contest. And as such, they always seek for ways of manipulating the system to their advantage. Now, let me break it down. Assuming in the normal course of events, where you file a matter, and a matter is defended properly. When public matters like this are filed, it is usually taken to the media to announce that a certain case has been filed by ABC against XYZ. The matter has been assigned to a particular judge. The particular judge has fixed a particular date for the hearing of this case. And then because it's a public institution, the court is a public place, members of the public are able to come, witness these proceedings, and when you take this normal course, 3 months, 6 months, and everybody sees that this thing was done in open court. Even if this same judge has delivered this same judgment after a period of 4, 5, or 6 months, when everything has taken its normal course, there wouldn't be this public outrage like we are having now, because this matter was secretly instituted
and expedited.
Hastily and expeditiously determined, and sundry orders have been given by the court directing the Attorney General to go and delete. It is not the functions of the Attorney General of the Federation to go and delete any section of any law. The powers of this court, as granted to it by the Constitution, is to declare any section of the law which is inconsistent with the provision of the Constitution as null and void. And that is where it stops. So for a court to direct the Attorney General of the Federation to go and carry a razor, or to go and carry a cleaner or razor blade to exercise a part of a particular legislation passed by the National Assembly, that is unheard of. So when things like this happen, it sends outrage to the consciousness of the average Nigerian and of the Nigerian public. And this is why we are having this outrage from all sections of the country against diverse political platforms and against diverse sections of this country.
But I'm actually curious to even know how well are Nigerians informed about this thing, because for me, it took last week Monday for me to even understand what just happened. Then all of a sudden now today we are discussing that they overturned it. You don't understand, you know, how sensitized are the citizens? Because again, if I would go back to that question I'd asked earlier, that if the people that we are appealing to, their consciences to do the right thing and start to go and go to the appeal court for this to be upturned, if they refuse to do it, right? Because again, it's political season. I really do not trust any politician. Do you understand? We take them for what they are, because it's possible that the same National Assembly, they are happy that this is happening. It's possible.
Of course.
You know, you never can tell. So if the people are sensitized enough to even understand the gravity of what has happened, right? How much is going to impact, you know, the electoral processes. You know, it's possible that the outcry that we're talking about might be a lot more, the pressure might be a lot more if it's coming from the people. But if they don't even understand what is going on, so how do we even sensitize people to understand that this is actually like almost robbing off you know, our elections or something?
Well, I started this program by commending you.
Yeah.
This program of yours is sensitizing the public.
Yeah.
The public, the average Nigerian public, the average Nigerian is aware of political happenings in his country, despite the myriad of challenges that we face every day. Nigerians love their country and they want to see their country governed better. It is people like you who create and give the platform to Nigerians to air their views, to speak out against the abuse of office by politicians, to clamor and yearn for the changes they desire in the Nigerian political arena. And it is part of this sensitization, part of this speaking out, that has given birth to this legislation that all Nigerians are so happy about. Now, on the day the president assented to this law, majority of Nigerians were very happy that for the first time in a long time, we have a good electoral law. When the president requested that they amend Section 94 sub 12, the day the National Assembly rejected that request, Nigerians again were happy, and it was carried all over the media, social, conventional, and print media. So it tells you that Nigerians know what they want. Nigerians want a good country, a better country. They want an improved political environment. They want a better political process. And all of this we are talking about now are all the components that will guarantee us a better electoral and political system.
Oh, wow.
So Nigerians, through you, through myself, will continue to speak.
Awesome.
And the momentum will continue to gather. And the politicians, a time will come, whether they like it or not.
Thank you so much. Now go there, Aliyu. Lemu. All right, so good evening, ladies and gentlemen. It's really disheartening that people are appointed to serve, not now only think about themselves. A lot of things are going wrong here, but what people in positions of authority are thinking is ways of perpetuating themselves in office. We need the professional bodies to intervene, to put a stop to all these embarrassing situations. May God help us. This is from BC. Thank you so much, BC. You had a comment, but it's quite long, so I will have to move on. Thank you so much, Ali. We had a fantastic conversation. Thank you, Manny. Now, before we go, do ensure you follow us on Instagram. It's at PlusTvAfrica. You can interact with us further. Drop a comment. More importantly, follow all our engagements online. Like, share, invite your families and friends to watch and follow the conversation. Now, if you missed today's quote, here it is again. You need to sit on this quote and think through it. Judicial judgment must take deep account of the day before in order that yesterday may not paralyze today. This is a very deep quote. You need to go and sit on it and think, whatever decisions we're making, you have to understand that it might paralyze our tomorrow. We'll see you guys live at 8 p.m. tomorrow as we bring another great conversation to your screen. Enjoy.